Good evening, students. Myself, Nisha,
and CA Shraddha.
Welcomes to you all on today's live learning classes on paper 4 of your final course, that is the Corporate and Economic Laws. Dear friends, you are aware this is our last class of this batch, and you must be seeing that all the classes are over except this topic containing chapter 11th and 12th of your syllabus. So this chapter 11th and 12th deals with the compounding of offences, adjudication, special court, NCLT and NCLAT. So here we have combined both the chapter 11th and 12th of your syllabus so that you can easily make out what are the various redressal dispute mechanism available under the Companies Act 2013. So we will be trying in this chapter to relate and cover all the important aspects related to the dispute redressal mechanism under the Companies Act related to the matters with the companies. So if you see in this chapter, we are broadly covering about the dispute mechanism, whatever are being available under the Act. We have combined everything in a single chapter so that you can easily make out and correlate what are all the mechanisms of adjudications are there in the Act and how do they function, how they are being established, and in what way, what are the offenses or the jurisdiction under which they can try the different nature of the offenses. Besides with that, we should also be discussing further with respect to the trial of offences. Suppose if the lower court has given any decision, then what will be the next step? Of course, the appeal, or it may be a revision. So in that case, we are covering that provisions. Besides with this, we are also having the mediation and the conciliation panel. So this is again the third, and you can see that again another kind of most effective kind of alternative dispute redressal mechanism available in the Companies Act. And also we shall be discussing about the adjudication of the penalties, how the penalties is being levied on the parties. So how the whole process, the mode, the manner in which the adjudication of the penalties takes place. That will be discussed at length and in detail, because twice or thrice after the enforcement of these rules, the question has been framed on this particular adjudication of penalties related provisions. Then NCLT and NCLAT. It is again one of the very important, the mechanism adjudication, and you'll be finding that now it has been playing a major role. Earlier, we were having many different bodies to regulate the company related issues, but now it has been made a sole body or a single platform where the issues related to the Companies Act can be taken into consideration. And these are the important aspects that we will be covering in an arranged manner. So you can make it out a linkage as well. You can be easily able to understand the concepts and retain, and that will be helpful you in the exam for retaining purpose as well as for understanding of the provisions related to the adjudication part. Since Shraddha, the students has very problem because these are all the procedural aspect actually. And students really find very difficult in understanding and retaining because the number of days in which they have to file the...
And the legal language that is used.
Yes.
Since we will be dealing totally with the legal provisions. Law is basically legal provisions only.
Absolutely.
But these are very monotonous as per the students. So we will be having an aim. We have an aim that we will be trying to not only tell you that what the provisions are, but simultaneously we will be telling you how to read them, revise them also, and how to memorize them.
Actually, yes. And so also be summarizing at many places, many of the detailed provisions. So that will be just helping you while revising of the subject.
Because the ultimate aim is that once you have understood in these provisions, more than understanding, it's about how you will write them in the exams. Many a time the student, there is not much to understand here. Understanding is from the point of view what the law is saying. But the main thing is that how will you be writing it in exam, and that you can do only when you have memorized it.
Yes, and it's since there's a procedure, every step is there. So you need to link each and every step, and then only you will be able to correlate what actual the procedure is. So try to understand and read in the manner, in the order, whatever has been prescribed under the Act, though we will be just simplifying the provisions for your ease of understanding.
And sometimes we will be using something... codes and everything so that you have a easy memorization of the provisions. and that you can use during your examinations while writing them. So let's start with the session.
So first we are just explaining you what does the dispute redressal mechanism means. Actually, dispute redressal mechanism is a process. You can say it is a process that deals with the disputes which is arising between one or between more than one party. That means there will be two or more parties who are involved in the business or the legal relationship. So whenever there is an existence of legal relationship, whether maybe through the, you can say the nature of the act of the business. So in that case, many times the dispute is being arises when there is, you can say there is a non-fulfillment of any terms or conditions specified under any agreement which has been entered during the transactions that has been made for conduct of any business. So at that time, it is possible that dispute may arise due to some non-compliance or some default of the terms and the condition that has been specified. So in that case, you can go to the dispute redressal mechanism. So it is a process basically. So this deals with these kinds of the disputes.
Just a moment, ma'am. Dear students, can you see the notes properly? Because we are having some queries that they are not able to see the notes properly. So
yes, students, please confirm so that we may proceed further with our session. Okay, let's continue. Okay, then if you see the right to seek redressal, actually what the thing is that every citizen of the country is having the right to seek the redressal with related to any grievances or to access to the justice. You know, we have got an important, the rights, the fundamental rights which has been given by the Constitution of India with respect to the awarding of the redressal right or to seek for the justice. So these are the rights that is guaranteed, that are being guaranteed.
Thank you, Janvi.
Yeah, thanks, Janvi. So these are basically provided as a fundamental right that is guaranteed to all the citizens through the article given under 14 and 21 of the Constitution of India. So what it happened, it gives the right to get the fair settlement of the genuine grievances by legal proceedings in appropriate timing. This is very important. First of all, there should be appropriate procedure and then within the appropriate time. So this has been provided to the redressal mechanism, and the aim of providing this single, or you can say the various sort of the dispute redressal mechanism under the Companies Act is with the intent to provide speedy justice and to ensure the efficient resolution of the company related issues in India. And that is why these various which were available on different forms now has been compiled under a one act under the Companies Act 2013. So what happens? The state takes all the necessary steps to provide fair, transparent, effective and accountable services that promotes the justice for all. State here stands for the central government basically. It can be central government or it can be a state government. So here there is a duty of the government to provide or to give access to the justice to all our citizens, and that is why it has been made a fundamental right under the Constitution of India. So under the Companies Act, let's see what are all the forums or the mechanism related to adjudication is available in the Companies Act 2013. So you will be seeing here. Yes, so let's take it that way. Click here. So we are having actually first the special code. This is being contained under the legal provision 435 to 438 of the Companies Act 2013. Okay, the first one is the special code. Fine. Second important mechanism is the mediation and the conciliation panel, which is being given under section 442 of the Companies Act. Just write down in short the provisions also so that students can easily make it out. MCP, that mediation and conciliation panel under section 442, special code given under section 435 to 438 of the Companies Act. Why I'm reiterating the section number here? Just so that you can retain whenever you are reading any act along with the section number. So definitely somewhere you are able to remember that particular sections also along with the important aspects of the provision. So got it? The first, second, and the third is the compounding of offences. This is again the another kind of the mechanism whereby parties enter into a settlement or they compound with respect to the commission of any offense. Then next third, which is deal with the section 441 of the Companies Act. Now, next type of the adjudication mechanism is serious fraud investigating office. So investigation office, so you will be finding here that it is being covered under section 211 and 212 of the Indian of the Companies Act 2013. Then next is the NCLT and NCLAT, right? It is being covered under section 407 to 432 of the Companies Act 2013. So you'll be seeing broadly we are having 5 the forums available for adjudication of the offences. So you must be seeing this all offences under the Companies Act has been given so that to ensure the speedy disposal of the matters as well as efficient resolutions of the company related disputes. This is an overview of what are all the mechanisms available over here. And if you see any kind of the trial of offences, basically it depends upon the nature of that. And if you see broadly, there are 2 types of the nature, or you can say 2 types of the matters that are being brought before the, before court, or you can say
any
redressal mechanism, you can say. So basically there are 2 types of the suits, you can say. One is civil suits or civil matters. Civil suits or civil matters. And the other one is with respect to the criminal suits and the criminal matters. Fine. So whenever there is a adjudication of any of the offences, it will fall either within the purview of the civil matters or either within the purview of the criminal matters. So what are the civil suits? You should have a brief understanding why I am just making you understand about the civil suits or about the criminal suits, just because so that you can make it out when any of these forums that we are going to discuss have the power of the criminal courts when they are acting as per the CRPC code and when they are having the civil powers as per the Civil Procedure Code.
CPC.
Yes. And that is, I'm telling you, these are the 2 types of the matters being related over here. And that is why they fall under the 2 previews. One with related to the civil matters and others related with the criminal matters. So that civil suits are generally pertaining to the property, or you can say it pertains to any kind of purchasing that is being done, or related to some family issues, matters are there, divorce and all these things. So these are the civil matters. Okay. And here generally the parties, what they do, they just demand for the compensation. This is the main important difference, that they demand for the compensation. Fine. And in the case of criminal courts, here what happens, this deals with generally with the commission of an offense, right? So here what happens, the parties demand for the punishment of the person. So this is the difference here. There is a punishment is the factor, and there in the civil courts, there is the compensation, which is making the difference in the nature of the 2 laws, you can say. In fact, these 2, both the laws are of procedural in nature. They are the procedural law, and that is why they are prescribing the procedures related to conduct of the trial with respect to the criminal nature of the offences, as well as with respect to the civil nature of the kind of the whatever default has been committed. So when you talk about procedural law, so let us be telling in the civil law and as well as in the criminal law. In civil law, you'll be seeing that there are, you can say that rules are there, as well as order is there, prescribing the, regular procedures. Whereas in the criminal law, there is section and schedule. So this is the broader difference in the procedural law of civil as well as criminal law.
There is no need for you to memorize all these things. These things are just for your understanding, that when we will be going through the chapter and the notes, at that time you will be in a position to appreciate that why we have told you all this, and then you will be in a position to remember the things better.
Later on you realize because whatever at certain places, somewhere certain mechanism, just judicial forums has been provided with the civil powers of the court, and at some places criminal. So there you will not be in a confusion if you understand that what is the difference, what sort of the matters they are considering, and because of that there is a difference in the powers also that they are going to get from these laws, similar to these laws on these forums also.
And then while writing the answers, we get very many times confused that whether we have to use the word that as the powers are vested with under the CRPC or as vested under CPC. So once you understand this thing, it will become much easier for you to write. You don't have to memorize that where we have to use CRPC and where we will be using CPC. It will be a cakewalk for you. Good evening, Namrata.
Yes. Then moving to the now first form of the adjudication mechanism, that is the special courts.
So we have seen basically 5 kinds of redressal mechanism. The first one that we will be discussing is the special courts. Just a moment. So the first one is the special court. If we have to look for the aim of establishing these special courts, I have just one word which all of you must have heard the dialogue. Tariq pe tariq, tariq pe tariq. So what does that mean? We all know that the cases that were being given to various redressal mechanism authorities before this enactment of the 2013 Act, they were taking lot of time. So there were pending issues. There was a lot of pendency. So for speedy trial, and rather I would say speedy prosecution of the offenders. So that's why, remember, tariq pe tariq. So the special courts were established with a view that it will result in faster prosecution of offenders. So that was the basic. And this is a special features of our Companies Act 2013. So like it has been almost a decade. It will be a decade now.
Yes.
But we can say that these special courts are a brainchild of our Companies Act 2013. So if the students can ask that, ma'am, if the speedy trial is coming here, can't they go through the regular mechanism? Yes, they can. The people, the company and the other people have that power that they can go through regular courts for the trial of the offences under the Companies Act. But what will that do? The procedure will be longer. Here, the procedure will be much shorter. So now we have to learn that what that procedure will be. So I told you that this is the brainchild of our Companies Act 2013. So these special courts, that section is 435. So these special courts, we are saying that it's the brainchild of the Companies Act 2013. Who formulated the Companies Act 2013? The MCA, the Government of India. So the Government of India may by notification for the purpose of providing speedy trial of the offences under the Act. Which Act? The Companies Act 2013. Establish, designate as many special courts as may be necessary. And then we have given that under the Companies Amendment Act 2020 has excluded offences under section 452. That is punishment provided for wrongful withholding of any property to fall under the jurisdiction of special courts. क्या बढ़ दिया मैडम?
अब यही तो बात है, इन्होंने इसको अलग से exclude कर दिया. That means specifically if something is provided, that means that only particular that offense has been excluded. Rest, the other offense being covered under the Companies Act will fall under the special court of the Companies Act.
So as per section 435, let's memorize it. Who can do it? The central government by notification. For what purpose they will do it? For speedy trial of offences under the Act, can establish as many special courts as that are necessary. And then they have given a proviso saying that offences under section 452 are exempted, that they cannot fall under the jurisdiction of the special courts.
Here I would like to add one thing, because nowhere in the Act a special court is defined. Let me tell you very frankly. Now, what is special court? You have to relate it from the definition of the court given under section 2, subsection 29 of the Companies Act. There it clearly provides what are all the courts being termed as, what are all the different types of the courts being included over there. So you must be seeing under the definition, the first is given the High Court, then there is given the District Court, Session Court, and then there it includes the Special Court, fourth number. And then after Special Court, there is you can say the Metropolitan Magistrate, and then Judicial Magistrate, first class. So these are all the courts which are being governed or being there in the Companies Act to regulate the companies related matters.
So now we have learned that who will establish the special courts, and there is a line, establish as many special courts. So that means there will be many special courts.
Yes.
So now we have learned establishment. Some will be guiding that what will be the composition, who will all be participating in the special courts.
Definitely they cannot itself carry on forward, or someone must be there to regulate and do the functioning. So of course now we need the composition.
So the way we are talking, it's for your linking, that establish ho gaya. Now the next point has to be their composition. So now they have bifurcated these special courts depending on the nature of the offense that will be dealt by it. Let me say that a special court will be bifurcated on the basis of the offenses. And nature of the offenses, they have categorized in terms of the imprisonment that can be given. And the only thing that you need to remember here is 2 years or more and other offenses. This is the crux of the composition. So now let's read it from that point of view. Composition of special court is bifurcated into 2 parts, depending on the nature of the offenses to be dealt with by it. A special court shall consist of. So we told you with imprisonment of 2 years or more. So the gravity is more. So it will be dealt by holding office as sessions judge or additional sessions judge in case of offenses punishable under the Companies Act 2013. Remember, here the offenses have to be specially in line with the Companies Act 2013. With imprisonment of 2 years or more, then it will be dealt in by the SJ or ASJ. And in case of other offenses, a metropolitan magistrate, a judicial magistrate of first class. That's it. So composition is easy. So suppose a 2 marks question comes for that, what will be the composition of the special court? Like a situation will be given to you and a part of 2 marks can be like this. So you now know how to answer it. Now we have known the composition also. The next part will be who will appoint, how these SJ, ASJ, MMM, JM will be appointed. We know who established the special court, the central government. So they only, the central government, with the consent of the Chief Justice of the High Court, within whose jurisdiction the judge to be appointment is working. So why we are saying with the consent of the Chief Justice within whose jurisdiction? We know that in case of special courts, the central government is empowered to designate as many special courts as necessary. So there will be more than one special courts. In that case, it has been bifurcated in a manner, so we can say in the manner of states and UTs. So they will be having a high court also there. So with the consent of the Chief Justice of that High Court, within whose jurisdiction the judge, we have told you about the SJ, ASJ, within whose jurisdiction these SJ, ASJ, MM and this to be appointed is working. Okay. The next is offences triable by special courts. This will again go back to our previous discussion of 2 years or more. Offences for which imprisonment of 2 years or more is prescribed shall be triable only by the special court established for the area in which the registered office of the company in relation to which the offense is committed. So now we are moving a one step further, that what is the procedure, that how things will be done. So we are saying that any offense where the imprisonment is 2 years or more, memorize, that has been dealt by SJ and ASJ. So is prescribed, they will be triable only by the special court within whose jurisdiction the registered office of the company is there. So if you link, you can see that everything you can link and remember. Okay. The next point is, in case there are more than one special courts, I told you, then it can be then where offences shall be tried by such one of them as may be specified in this behalf by the High Court concerned. Because we told you that SJ, ASJ, MM and all those people are appointed in consultation with the CJ of the High Court, though that line is there. So they only will decide that where this matter will be taken up. Okay. Next, we have learned about 2 years. Then if there are more than one special courts, then what will happen? Then when a person is accused of or suspected of the commission, so that means in this case, investigation of some sort may be going on, and it is not necessary that a decision has been taken that this is the imprisonment. Or we can say that they are not still sure that what is the further course of action. So where a person is accused or suspected, and we don't want the person to indulge in further wrongful activity. Then if you want a person not to be indulging in further wrongful activities, the immediate step has to be detention of that person. That's a logical step. So in this case, when a person or accused or suspected of the commission of an offense under the act, such person is forwarded to the magistrate under section 167 of the CRPC. So it's not necessary to learn this section 167, but definitely you can write CRPC, like Code of Criminal Procedure, because now there is very big point here. Everything in the special court will be derived or will be taking powers from CRPC only. So you can say such person can be forwarded to the magistrate under the respective section of CRPC. Okay. And now what are the powers of that magistrate? I told you the logical step is that person should be detained. So that person shall be detained in such custody as it thinks fit. Next, we have to define a time period for which that person can be detained. Okay. So here there are two limits. One is 15 days and the other is 7 days. 15 days in case where such magistrate is a judicial magistrate, and 7 days in case where this magistrate is an executive magistrate. See, you have detained that person now for how long? 15 and 7. 15 ka half, 7 and a half. Okay. Now, suppose now they come to know that it was not necessary to detain this person. Then, necessary ka ulta, unnecessary. So, where such magistrate that the detention of such person is unnecessary, he shall order such person to be forwarded to the special court having jurisdiction. So now, remember, we come to another, the person is accused or suspected of the commission of an offense under the Companies Act, then such person can be detained, and that detention can be for 15 days or 7 days as the case may be. We have learned that is a judicial magistrate or an executive magistrate, And if such magistrate considers that this detention was not necessary, then he shall pass such necessary orders to be forwarded to the special court having jurisdiction. Okay.
One thing, I'm interrupting you, Shraddha. Just students, one thing, when it is being said that a person is accused or suspected of commissions, that what happens, the police may take an, look into this matter. They will just file an FIR against the person on the basis of, yes, some wrong has been done by the person. And just that to go into, just finding out and tracing out what has happened, he will just prepare the report and everything on the commission of the act. And then after that, where he finds it within the 24 hours, they are not able to complete this investigation. What they do, then they forward such person to the magistrate under section 167 of the CRPC, because they can make it out that while finding out or during the investigation, they come to the conclusion that it is not able to be completed within 24 hours, and it's going to take more time to complete the investigation, to prepare a concrete report so that they can further move on their reports to the magistrate for further step of inquiry, which is the process of the criminal trial actually. So here in such a case, he is being forwarded to the, under section 167 before the magistrate, because that investigation is still incomplete, and they feel like, for the sake of what the ma'am has tell you, considering that something may not happen wrong, or considering that he may do something, or he may gain, or any kind of profit he may be driving if he has not been detained, any kind of wrongful step, or any wrongful act he may commit. So what in that case, the magistrate may authorize the detention of such person. This is why the detention is being made over here, and already well explained by the 2-1. So what is the difference between judicial magistrate and executive magistrate? Why is the difference of the period prescribed for their detention? So if you say the judicial magistrate is there, then he is in the control of, you can say under the High Court. Okay, with respect to the judicial magistrate I'm talking about, he's a legal person and he is in the control of the High Court. Plus he has the power of, you can say, the act which is judicial in nature basically. That is why their detention period is also longer. Yes. And when we talk about the executive magistrate, they are in the control of the state. And basically they deal with the powers which are administrative in nature. Administrative can be any power. We deal with like public servant related duties, which he has not complied, or something wrong he has done on his part with respect to performance of his duty. So that act can be said to be an administrative nature of the act. And for that, executive magistrate is the authorized person who can detain the person according to the prescribed period over here.
So the next point is, since we told you that here everything will be derived through CRPC, these special courts are vested with the same power as provided under the CRPC. Special court may exercise the same power for trial of a case as that of a magistrate having jurisdiction to exercise under section 167 again of CRPC in relation to an accused person who has been forwarded to him under that section.
And one thing more, that accused person doesn't mean that he has been proved as a criminal or an offender. Accused person is said to be till the charge is proved. So still nothing has been come into the, you can say, to the step of the inquiry.
Finalization.
Yes, it is just all this process is going within the limit of investigation, and after the investigation, they have been sent for further step for inquiry, and everything is presented before the magistrate, and then further the charges are being marked on that particular fellow, and the charge has been taken into consideration in the court, and they are being tried. And a trial is made, they have been examined, and when it is proved, then they are said to be a offender or the criminal. Until that time, they are termed as accused person.
Then we have to learn about the cognizance of offense by special court. A special court may, upon perusal of the police report, as ma'am told, of the facts constituting an offense under this act, or upon a complaint in that behalf, take cognizance of that offense without the accused being committed to it for trial. So as has been already explained, this point is self-explanatory, that when can the special court take cognizance of the offense? Upon the perusal of the report by the police officer, or upon the complaint in that behalf. Then next is a very special point, which is a summary trial.
Yes. Summary trial. Basically, if you see in any of the court, you will be finding there are 4 kinds of the trials being taken in a court. So first is the session trial. Let's explain through this notes. Yes. Basically, first, what is a trial? If you see in a broader term, trial is actually process in a court of law. How does the court go into an order? What is the procedure? How they look into the matter? How they just find out or try? Yeah, any kind of the proceeding which takes place in a court is a trial, right? And it starts after the investigation. Once the police has done its duty, submitted its report, then it's being started after submission before the magistrate their reports. So after the investigation, the trial begins and it ends with acquittal or with the conviction for an offense. So this is a trial. So basically this whole procedure which takes place in the form of a trial are of 4 types. First is the session trial. Session trial, it is being taken in the session courts. Okay. And under this session trial, such kind of the offenses are being taken into consideration, which are punishable with the imprisonment of more than 7 years or life imprisonment or for death. Okay, if any of the offense is punishable with the punishment of more than 7 years, okay, or life imprisonment or with the death, then there will be a session trial for such kind of the offenses, right? So this is one kind of the trial. Then other kind of the trial is with the warrant trial. So what about the warrant trial? Only those kind of the offenses which are punishable with death or imprisonment for life and imprisoned for more than 2 years. Yes. So it is being dealt with, such offenses are being either the death, okay, or the imprisonment for life or imprisonment for life, okay, or there is a imprisonment for more than 2 years. If these are the offenses being punishable with these mentioned punishments, then there will be a warrant trial, right? Right here, life imprisonment. You can see the difference. 7 years or more punishment is different, and here 2 years, more than 2 years punishment is prescribed. Rest, both are the same. So this is a warrant trial. And the third type of the trial is the summon trial. So in this kind of the trial, the offense punishable are such offenses which are less than 2 years of imprisonment. If offense is of the having the punishment of less than 2 years of imprisonment, then that trial will be said to be a summon trial with respect to the summon nature of the case. Now here, since in the special court we have come across with the summary trial. So what is a summary trial that you should understand in order to have the understanding? So summary trial actually basically it's the trial for speedily disposal of the cases with simple procedure, okay, to follow, and recording such trials are done in a summarily manner.
So main thing is it's speedy.
Yeah. And second, simple procedure, not just like the normal trials, because there's a very long procedure. Each and every step is there. So here we shall be following a simple procedure, right? And also the recording that the procedure has or such trial has been done summarily. That is to be brought into the records. And in these types of summary trial, only small cases are taken in the hands, whereas the complicated cases are reserved for summon and warrant trial. So here we shall be in the special court, we'll be dealing with the summary trial of the offenses. So now let's go to the provision.
So here we have come to know that what is the meaning of summary trial. With this, you can easily now understand that only those things that will be not of that grave nature will be taken by the special courts for summary trial. So the special court may, if it thinks fit, this line will be used n number of times, try in a summary way any offense under this act which is punishable with imprisonment for a term not exceeding 3 years. So all the punishments for the sake of learning under the special courts 2 years or more, and in summary trial it's for a term not exceeding 3 years.
Yes.
So the special court will try in a summary way any offense under this act, which is punishable with an imprisonment for a period of not exceeding 3 years. Then what? In the case of conviction in a summary trial, no sentence of imprisonment for a term exceeding 1 year shall be passed. So why we have given these 2 points separately? If you see them clearly, you can see that one is the charging section content, that when can we do a summary trial? Only in case of imprisonment, in case of offenses where the punishment is not for a term more than 3 years. And even if you have to give a sentence for imprisonment, then that cannot be more than 1 year. So these are two different things. One is when that summary trial can be done, and then what can be done in that summary trial.
Yes, with respect to that particular trial, whatever the offenses they are trying during summary method of the trial, at that time the punishment that can be, yes, what punishment can be awarded for commission of such an act. So that has been provided.
So Namrata has asked us a question. Cognizance of an offense means.
Yes.
So if we see it in plain language, we can say that cognizance of an offense is cognizance. What does cognizance mean? It is the deep understanding of something. So if we are saying cognizance of an offense by special court, that means when can the special court have a deep understanding, deep knowledge? And if it is a court, then it is a when can it have an investigation?
Anything, any step taken forward towards the conduct of the trial, that is the cognizance of offense. With respect to offense, whatever the steps they have taken, that is the cognizance
if you need
of the
to,
offense.
And how you will understand what will be the steps. Yes. So moving on to our next point, it is appeal and revision. Section 437. The High Court may exercise all the powers conferred by chapters 29 and 30, which deal with appeals, reference and revision of the CRPC on a High Court, as if a special court within the local limits of the jurisdiction of the High Court were a court of session trying cases within the local limits of the jurisdiction of the High Court. आगे समझ?
बच्चों को नहीं समझ में आया होगा क्योंकि बोला ही इस तरह हमारा जो लॉ है एक्चुअली बेसिकली समटाइम्स law is written in such a manner that you cannot easily draw the interpretations, but here you need to draw an interpretation to understand what exactly the law is intending here.
Here is a need.
Yes.
So, if I can explain in Hindi to them, as if आप इसकी नीचे वाली लाइन पहले पढ़े, as if a special court within the local limits, क्योंकि हमने बताया हाई कोर्ट की jurisdiction की हमने बात करी थी. If you remember हमारा discussion, if you remember the discussion which we had, that high court. So within the local limits of the jurisdiction of the high court were a court of session, because under the high court there is a sessions court also.
Yes.
We are trying to equate our special court. This is we are trying to explain, and for your learning, we are trying to equate that our special court in line with that sessions court. If you see, understand, were a court of session trying within the local limits of the jurisdiction of that high court. Simply saying, the special court within whose jurisdiction the special court is lying, it will be having the same powers that would have been provided to a sessions court under whose jurisdiction the sessions court would have been there. Simple.
Yes. That means the high court will be having the power of appeal, reference and revision as per the CRPC code. But here we are just considering, as Shraddha said, at par that considering that special court would have been a session court, and within the local jurisdiction of the which of the High Court it is following, that court will be having the power of appeal, reference, and revision. So here the special court is since under the jurisdiction of the High Court. So here the High Court will also be having the
Power.
appeal, reference, and revisions power.
So this is with reference to the High Court. That
Yes.
which High Court will be having that power? We have told you that the special court, the central government may designate as many special courts. In some of the states or UTs, there is just one special court. In some of the states, there are more than one special courts. So all these provisions are such that they will try to eliminate any kind of, you can say, a difference of powers that can arise. So this is from that point of view, that who will be having that power for appeal, revision, and reference in respect to that special court.
Yes.
So the next is application of court to proceedings before special court.
Yes.
So which code we will be talking here about? Obviously, CRPC, Code of Criminal Procedure 1973, shall apply to the proceedings before a special court. And for the purpose of the said provisions, the special court shall deem to be a court of session. This was a discussion just before it also, or the court of metropolitan magistrate, or a judicial magistrate of first class, as the case may be. And the person conducting a prosecution before a special court shall deem to be a public prosecutor. So in this case, again, we are defining the powers. Who has those powers? So what happens is, if you have to remember it in an easy manner, the provisions of this CRPC, obviously in the case of special courts, shall apply to the proceedings before a special court. And for this purpose, the special court shall be deemed to be a court of session, that is a sessions court. Or we learned it earlier, magistrate, MM, you remember MM and JM of first class. So take it from there again. Or the court of metropolitan magistrate, or a judicial magistrate of first class. Let's end it here. Then the next point is the person who is conducting a prosecution before the special court. Usko bhi to hame same powers deni padenge. So that person shall deem to be a public prosecutor.
Yes. अगर आपको पता होगा, under the CRPC code, there is a public prosecutor who stands from the government side, okay, against the accused. So here what happens, the public prosecutor as well as the company prosecutor, here in the special court, the company prosecutor is being appointed, and they will be having the same power to represent in the court on behalf of the government. Because generally there are certain kind of the offenses which are causing injury to the public interest when it is affecting the society at large, because any kind of the crime is there that is affecting the society ultimately. So in that case, in most of the cases, unless there's a private party, so you'll be finding the other party, the party who has brought the prosecution against the offender will be a government. And from government side, the public prosecutor will be representing the case. So whereas in the special court, what we do in place of public this prosecutor, as they are in the normal courts, we just take the company prosecutor and they have the same power, right?
Same as that public prosecutor.
Yes.
I hope students, you are able to understand what we are teaching you and trying, and you are able to memorize at least some of the things through the small knickknacks that we are trying.
Because generally the MCQs, if direct nature of MCQs are being asked in the examination, they touch upon these kinds of issues only. They try to understand whether you are able to understand the jurisdiction, who all are, empowered to look into that particular kind of the offenses. So you need to understand. And when this public prosecutor in place of this person, company prosecutor will be there with reference. So you should know the differences, and when they are at equivalent or at the, you can say the references are being changed with respect to the particular act. But yes, you need to understand the provision with all this clarity so that you can easily make out and find out what is the correct answer provided in the MCQs.
So the next is offenses to be non-cognizable. So this is one of the biggest pain area. What is this cognizable? And what is this non-cognizable? So students, there is one more thing. One is cognizable and non-cognizable, and the other term that is used again and again is cognizable offense, non-cognizable offense, and the third other term was when the court can take a cognizance.
That is cognizance of offense.
Yes.
Now there's a difference. Just mark all these differences.
So if we see cognizance, like Namrata asked, what is cognizance of offense? So it was about understanding of the offense, understanding, investigation, उस चीज के बारे में पूरा जानना, in-depth knowledge about it, how to gain that in-depth knowledge. Now, here we are dealing with non-cognizable offenses. Cognizable offenses, in simple terms, if I say, where without seeking the permission or the warrant, a person can be arrested, in simple words.
Yes.
And in term, and where we are saying non-cognizable means the arrest can be made only after a warrant has been issued. That means permission of someone higher, like a magistrate, is necessary for providing, for arresting a person. So the main differences with respect to, for you guys, is with respect to cognizance. In case of cognizable offenses, you can arrest the person without the permission or warrant. But in case of non-cognizable offenses, you cannot arrest the person without the permission of the magistrate.
Yes. That means when the offense nature is of severity, it is of heinous type of the crime, or it is very grievous, that in such a case, there will be a cognizable offense. And here, without waiting for the prior permission of the magistrate, police can arrest without issue of warrant also. Okay. And whereas in non-cognizable case, these are of lesser severity in nature. So in that case, you first need the prior permission of the magistrate, and then later on, they can be arrested by issuing of the warrant.
So now we will move to our section, that is section 439, offenses to be non-cognizable. As the heading suggests, so it means, if we look at the heading, often कौन से offenses है जहां पर आपका arrest एकदम ऐसे ही नहीं हो सकता. So every offense under the Companies Act 2013 shall be deemed to be non-cognizable. Non का सुन के हमें लगता है कि बेचारा बच ही नहीं सकता, but इसका उल्टा है. It's here, non is not meaning that you are gone. It's more about that you cannot be arrested without the warrant. So every offense under the Companies Act is a non-cognizable offense. As is the habit of a Companies Act, they have provided an exception. And the exception is section 212. Nisha ma'am just said that in case of cognizable offenses, the seriousness or the gravity is of the higher level. So gravity, we know that 212 deals with SFIO, as the name suggests, serious fraud investigation. So the offenses that have been specified under section 212 subsection 6, only that will be excluded here. All the other offenses under the Companies Act are non-cognizable. Now, next, a court can take cognizance. See the difference. In the first point, they are talking about non-cognizable offenses. In the point number 2, the legal language is saying about cognizance of an offense. Matlab, knowing about that offense, understanding whatever words you use. So don't confuse the two. So a court can take cognizance of an offense alleged to have been committed, जिसके लिए उनको कुछ पता चला है, that they have come to know something under that, because we are dealing with the Companies Act, by any company or any officer in the company who will have, who will commit that offense. Just think about it. Either the company we have, because everywhere we are penalizing the company also due to the separate legal entity. So we are saying the company or any officer. Logically, who will be the aggrieved party, who will be filing the complaint? The shareholders, members, registrar, because registrar is directly dealing with the company in relation to the various formalities. And the fourth person, the central government itself. So we are saying a court can take cognizance of an offense alleged to have been committed under the Companies Act by the company or any officer of the company only after a formal or a written receipt of the complaint. The key word here is oral receipt. Complaint will not do. Written complaint by the registrar, shareholders, members, or any person authorized by the central government. So, next 4 points, though we have given it in a sequence. So, let me just read it and then I will make you how you can remember it also. A court can take cognizance of an offense in relation to issue and transfer of securities and non-payment of dividend on a written receipt by any person authorized by SEBI. Then the fourth point is with respect to complaint is given by the registrar or a person authorized by the central government. The presence of such officer before the court trying the offence shall not be necessary unless the court requires his personal attendance at the trial. Then the fifth point is with respect to cognizance of an offence when your liquidation process is going on. And the sixth point is with respect to in case of a government company, the court take cognizance of an offence under this act which was alleged to have been committed by any company or officer on the complaint in writing of a person authorized by central government. So let's go back a bit. All the offences shall deem to be non-cognizable. Second, we have learned that who are the accused and who can file a complaint. Now, read this point 3 with 6. So, when the offense is related to issue and transfer of securities and non-payment of dividend, the complaint will be filed by SEBI. SEBI will not come directly. So any person authorized by SEBI. Now come to the sixth point. In case of a government company, the court can take cognizance. Who will file that complaint? Any person who has been authorized by the central government. So if a note comes to you, if that you have to write or remember something about this offenses to be non-cognizable, 4 points are done. Now, fourth and fifth point are also related from the point of remembrance. We have learned that if its complaint is by the registrar or any person authorized by central government, then they are giving them an exemption. They are saying that the presence of such officer before the court is not necessary unless the court requires that such authorized representative be present in person for the trial. Similarly, link this point with the fifth point also. In case of the provisions of taking an offense under this act by a company or officer shall not apply to any action taken by the liquidator in respect of an offense alleged to have been committed in respect of the matters in chapter 20. That is your winding up. Then in that case also, we are saying that the provisions shall not apply. So they have, wherever they have to safeguard their people, they are saying that shall not apply, or their personal presence is not necessary till the
Some
time.
sort of relaxation or exemption is given.
Yes. So this was all about the, you can say, offenses that are non-cognizable. For cognizable offense, that is your section 212, you will read it under the chapter of
4.
Investigation.
Yes. And basically there the offense are being dealt with the fraud, which are being punishable under section. It is 447 of the Companies Act.
Yes.
Now this is next another kind of the redressal mechanism. So as I said, this is one of the important and the most effective alternate of addressing the issues under the Companies Act. So mediation and conciliation panel, when we talk about, we are finding here there are two terminologies basically, the mediation as well as the conciliation. So students, if they look from a layman's point of view, they will find that there is no difference. There seems to be almost at same or at par. So you cannot make it out what is the difference between these two terms. So you should understand for the difference also, just for sake of knowledge, because at the further when you go at the higher ups or at the professional front, so you will not be made a mockery, oh, they doesn't know that this difference also. So it's just that when we talk about mediation and the conciliation, so what happens generally when we talk about mediation, mediation generally aims to reach an agreement between the parties and are enforceable by law. It means generally there is an agreement between the party to reach on a certain agreement or certain terms and conditions. They agree to do certain things. So there is an aim to reach an agreement between the parties through the way of the enforcement by law. That means some matters has been referred to them, and after referring the matter, they give certain kind of the recommendations, and that recommendation is back sent to the competent authority who has for whom the proceedings were pending actually. So it will go over there again. They will send their recommendation back to that authority only, competent authority, during where these cases were pending or being tried over there, and then they will take the decision. So they are enforceable by law rather than directly by the mediation or this conciliation panel. When we talk about the conciliation word, now what is that? Conciliation generally aims to come to an settlement agreement, okay, between the parties, and their orders or their decisions, or you can say their recommendations, they are being executable as the decree of a civil court. That means they just binds the party because their order is being executed such like a decree is being passed under the civil matters. So they have the legal binding force where the parties are being entered into a legal, obligation or legal relationship. So it has that key, it has binding force, and that is why the parties are forced to follow whatever the order has been passed. So this is mediation and conciliation. And if you see about first, about who maintains this panel of experts. Basically, mediation and conciliation panel consists of the experts over there. There are various experts in the panel. Now, someone must be there who must be regulating or, controlling the panel of the experts. So here the section 442 of the Companies Act defines clearly it is the central government who maintains the panel of experts, right? So central government is the main authority who looks at who all the experts will be there in the panel, and they shall be, and that panel will be termed as, the experts panel will be termed as mediation and conciliation panel, right? Now, the next thing is that with respect to composition, this is similar as in the special court we have come across with who is going to establish, who is going to appoint the persons who are being doing or managing that particular organization or the institution or the body that has been established. So similarly, some composition must be there. So here you'll be seeing, as we said, this is a panel of experts. So who all experts will be there? They shall be consisting of such number of experts with having such qualifications as may be prescribed. As may be prescribed means whatever may be prescribed by the government through the rules or something related to notifications. What are all the requirements to be an expert for being in the mediation and conciliation panel? Then third is mode for apply of mediation and conciliation proceedings. How the proceedings may take place. So in this case, you will be finding out. Yes. So you will be seeing that, yes, in the composition, one more aspect is there when we are talking about that experts must be having the qualification and all these things. So it says that during that composition, they will be mediating, they will be doing the settlement between the parties during the pendency of any proceedings. And it will be between or before the central government. First concerned competent authority is the central government, or it will be the tribunal or the appellate tribunal under this act. Means whenever the mediation is taking place during the party, the certain case must be pending or certain proceeding must be going on. And when they are not able to arrive to a certain conclusion, or somewhere they are stuck upon certain matters where they need that party wants with the mutual consent that certain settlement must take place between the parties. So they may refer to the courts under which their proceeding is pending to go for the mediation and conciliation proceeding. Okay, now how does they apply for this conciliation mediation proceeding? First, we have discussed with you what is mediation conciliation panel, who all are there, the person who are regulating this panel, who appoints the persons or the composition of this mediation and conciliation panel, and now what is the method for proceedings that can take place under the conciliation and mediation panel. So what happened? There are two ways actually when you apply to the mediation and conciliation panel. First way is when any party to the proceedings with respect to any proceeding which is pending before the central government, tribunal or appellate tribunal, they apply to the CG, yani central government, to the tribunal or the appellate tribunal. Party applies. Whosoever are the parties, they apply to the consent. You can say to the consent where your case is pending, or wherever your trial is going on, wherever your matter is being looked into it. So there they will apply actually. The parties will apply to them as the case may be. If the case is pending before the CG, then parties will apply to the CG. If before tribunal or appellate tribunal, as the case may be, the parties may be applying for yes, that we want to enter into a mediation and conciliation panel. So they will be saying for referring their matters. And after that, the CG, tribunal, appellate tribunal, as the case may be, they shall be appointing one or more experts from the panel. This is the one way they can apply to the mediation and conciliation panel for the proceedings. Then other is the way where the central government tribunal or the appellate tribunal, they may suo moto, where the case is proceeding, whatsoever may be the situation, whosoever it may be there, if the central government or a tribunal or the appellate tribunal before whom this case is pending, they may either suo moto, okay, they may refer the matter to the number of the experts from the mediation and conciliation panel, as the case may be, they deem fit. It is not decided whether there will be 2 experts, 3 experts. They may be any number as they may deem fit. They will appoint the number of the experts. And these mediation and conciliation panel shall follow such procedures as may be prescribed and shall dispose of the matter referred to it within the period of 3 months, okay, from the date of appointment of expert. Got it? They have to dispose of the matter. Whatever the matter has been referred to the conciliation and mediation panel, they have to dispose of the matter within the 3 months from the date of appointment of the experts, and then they will forward their recommendations, whatever has been made, to the CG or the tribunal or the appellate tribunal, as the case may be. Fine. And after the giving of these recommendations, again, the court, the respective court, the CG or the tribunal, appellate tribunal, may further carry forward with their recommendations and may proceed in their proceedings. But there may be a other party who is not satisfied with whatever the recommendation has been given by the panel. So what they can do, they can go into an appeal actually. They can give appeal in the sense they can raise their objection. Okay. And where they can raise their objection with respect to whatever the recommendation given in the respective code in which the proceeding is pending. Got it? And what are the code? Already told you there are 3 types of the code under which the proceedings are running. So in any of the court in which the case is proceeding or it is pending, in that court, the parties, the aggrieved parties who is not satisfying with the recommendation, they can file their objection. Fine. So this is how the conciliation and mediation panel works. Now, with respect to next kind of the alternate redressal mechanism is the serious fraud investigation office. This you must have dealt in detail under the chapter 4 of your syllabus that is being discussing over there, the chapter on investigation inquiry. Okay. And you must be seeing that with respect to inspection, inquiry and investigation, there we have dealt in detail about the SFIO, how it works, on what are the offenses, how do they do the investigation, inspection with respect to any sort of the offenses that are being done or committed under the Companies Act. Now here we are specifically talking about SFIO because this is also one of the alternate mode of providing you the redressal with respect to the disputes related to the companies. So here first we are talking again about the establishment of SFIO. So here you will be seeing again the central government shall establish an office of SFIO. Since any kind of the offense which are criminal in nature, they are said to be, somewhere related to the public unit. Already have said you to somewhere the government role is directly linked over there. So here mostly you will be seeing all these mechanisms are being established by the governments. So here also the SFIO is being established by the central government. How? By notification, right? And to investigate the frauds relating to a company. You know the intent, with what intent SFIO has been established, as the name reveals, fraud investigation. So they are being established to investigate the frauds relating to a company. Now, what is the composition? Who all regulate this body or conduct? In what manner the process and all this? Who are the bodies who are regulating and working over there? So SFIO shall be headed by a director. That means there will be a director plus number of experts from the different fields. Fine. And they shall be appointed by the central government. From where? From amongst the person of ability, integrity, and experiences in banking, corporate affairs, taxation, capital markets, etc. Means from different fields, they will be having the expertise knowledge, and from among them, they will be appointed. So all these experts will be having the special knowledge and the experiences.
Related to business, related to commerce, if you see.
Yes, these are all the field that we are talking about, whether it may be banking or the corporate taxation. These are somewhere regulating the business. You can see the occupation, professions. So that is why here you will be seeing these composition of SFIO will be led by the director plus the experts. Then what will be the function of SFIO? It says that, provision says that, where the CG is of the opinion that it is necessary to investigate into the affair of a company by the SFIO, on whose report someone will be complaining over there, someone may be, filing a report or complaint, something like that, then only the CG will come to know about the commission of any, offense or something. They will feel like that investigation is being required into the affairs of the company. So here, whenever CG is of the opinion on the basis of the report submitted by the registrar or the inspector, right? The next, where there's an intimation of an SR passed by the company that the affair needs to be investigated. This is another situation when the central government can look into the investigation part. Third is when any act is done which is against the public interest. Then fourth, on the request from any department of the central government or the state government. So in that case, if central government is opinion on the basis of all these complaints or the reports or the intimation, if finds that, or they may feel like they may by order assign the investigation of the company to the SFIO, and its director may designate such numbers of inspectors as they may consider necessary for the purpose of investigation. So here CG on the report of following for purpose, because the question may be asked on the basis of whose report that central government may start doing up the investigation, or they may assign for investigation to the SFIO. So you should know these are the 4 persons on the basis of whose complaint, when SFIO is convinced or satisfied, yes, there is a need to investigate, they may by order, assign the investigation to the SFIO, and its director will elect, or you can say they will designate the inspectors for the purpose of the investigation. Now, next important provision is the power of central government to appoint company secretary. This will be asked in the MCQs. However, as far as in the descriptive question, this probability is bit less, but yes, you never know. It may be combined with certain of any one of the provision and they may be asked the question. So already I have discussed with this part in the special courts. Already you are having the company prosecutors in place of public prosecutors, and they shall be appointed by the central government because they are the representatives of the governments. So again, they are being appointed by the central government for the conduct of prosecution under this act or under any of the case you can say, and they shall be having the same power and privileges as that of the public prosecutor as has been provided under the CRPC code. So remember, company prosecutor, public prosecutor, and same powers, right? Now moving to the next section, it is appeal against acquittal. This is being defined under section 444. And you will see any trial is either being ended with conviction or the acquittal. And generally in offense, one of the party is the government. So whenever there is an acquittal of the party, the central government will do what? Definitely, he will say his company prosecutor or authorize any other person by the name or virtue of his office to present an appeal against the acquittal. Government is feeling like that he is responsible and he should not be discharged from any offenses. So he may file whatever the decision has been given by the special court. He will file an appeal against that. And that appeal will be presented either by the company prosecutor or any person who is appointed and shall present an appeal from an order of acquittal passed by the court. But yes, it should be other than High Court. Please take a note that it should not be a High Court. If it is a High Court, suppose it is asked in the MCQs, check it out and giving an option in High Court also, which of the following is not a correct option with respect to filing of an appeal against acquittal. And one of the option given is the High Court. So you should know that no appeal against acquittal is filed in the High Court. So you can mark there the correct answer, because sometimes the questions are being asked in the negative also. So everywhere it's required, you should have a clear understanding of the provision. Something which is not applicable and then in asking in negative, the question you have to write down the answer accordingly and understand the requirement of the legal provisions. So such kind of appeal presented shall be said to be valid if presented before the appellate court. Now, the next is whenever any punishment is levied by the court or the special court, there will be certain factors on the basis of which the punishment is determined. It should not be in the air. Any punishment, pick and choose is not there. So some factors are there. On the basis of factors, they decide how much punishment should be levied and what sort of the punishment may be levied against that accused.
Just listen to this very carefully because the next provision is also related to this one. And then you will understand that why things are happening like this.
Yes. So if you see here, you'll be finding there are SNINR. You can, in order to remember what are the important factors, you can just write an acronym SNINR. S means the size of the company. What is the size of the company? Okay. Then they will talk about the nature of the business, what all the business they are being carried by the company. Then they will talk about the injury to the public interest, nature of default, or if the defaulted is of a repeated nature, that in that case, your penalty or the punishment or the amount of fine or imprisonment will be increased considering these factors. So it may vary considering these factors. If some company is a big company and when they are doing the offense, definitely they may be charged more penalty considering their, their competency. You can say they are holding much fund, much capital. So accordingly, they will be levied more penalty. And if the nature of the business carried on by the company is something else and they're doing some illegal business on the name of the business, on the nature of on the basis of their business, whatever they have shown in their memorandum and doing something else, some illegal, then again, accordingly, they will be levied this penalty or the punishments. And something more, if it's injury to the public interest, something at large, it is being done, then of course, the gravity, considering the gravity of this offense, the punishment will be laid accordingly.
So here you can use even the acronym RINS, wherein the last E can be replaced with simply in your mind by N. So it is, you can easily remember it.
Whatever you
Yes.
like. Yes, this is all up to you. Whether in the sequencing order you prepare or something jumbling of the words, you can draw some
It's
kind
for
of words.
your
Yes.
remembering point. It's from your remembrance point of view.
Yes. Now moving to the next concept.
So the next is linked to the above only. You can link it in the manner that the quantum of penalty or punishment is dependent on few factors, wherein we have also read one point as size of the company, the nature of business and all those things are there, but size of the company is there. So next is lesser penalties for certain companies. So what are those certain companies? One is 1-person company, the other is small company. And whenever 1-person company and small companies are there, startup companies also are towed along. So, and here one company is additional if you see, the producer company. Generally what happens, 1-person company, small company and startup companies are generally together. Here where there is one more company, that is a producer company. Since the size of these companies or their level of operation is less, so what happens is the government would intend that they should not be penalized with such heavy punishments because they will not be able to do with those punishments. So what they are saying is that if an offense has been if an offense has been committed by the company or the officer on default of the company, because offense will be created by these two people only, of a 1-person company, small company, startup company, or a producer company, then such company, its officer in default, or any other person. The point here to remember is any other person, as the case may be, shall be liable to a penalty. Choti company hai, small hai, so we have lessened. Liable to a penalty not to be more than 1/2 of the penalty specified in that section. So what does that mean? That if in the main section the penalty is 50,000, so for this OPC, small company or producer company or startup, the maximum limit if there is 50, for them it will be 25. Half. Then the next is, then there is a further one more clause to it, one more condition. Once they have said that it will be half, then they are saying that the penalty in case of the company, if you have to penalize the company, it cannot be more than 2 lakh. Suppose the half is coming till 50 lakh, suppose, then it cannot be more than 2 lakh. And if the penalized person is the officer or default or any other person, then it cannot be more than 1 lakh. Okay.
Even one more thing is that there's a double cap, you can say.
Yes.
One cap is not more than half of harm. It is restricted up to half of the penalty, whatever is prescribed in the provision under which the offense is committed. Okay.
Yes.
And the other limit with respect to the companies as well as for the persons or the officers in default or any other person. So with respect to the company, they are limiting 2 lakhs maximum, as well as with respect to the officer in default or any other person, it is 1 lakh.
So if you see what can be the maximum amount that the OPC is subject to as a penalty.
Yes. So if any student is watching, we are looking forward for your reply. Yes.
Yes. Thank you, students. So that means you are being attentive of what you are listening here.
Yes.
Thank you.
Yeah.
So the correct answer is
2 lakhs.
2 lakhs.
Now, this is again important concept, adjudication of penalties. Now, how does the penalties is being, adjudicated? How they're being decided? How they are being levied? So there's a procedure actually. There's a manner. So accordingly to that, we have to read section 454, which defines about the adjudication of the penalties. If you see for the adjudication of the penalties, the central government by order in the official gazette, what they do, they appoint the officers of the central government to act as an adjudicating officers. And such appointed officers shall be not below the rank of the registrar, right? So they will be appointed for adjudicating penalties. How? As per the manner prescribed in Rule 3. Now, what is the manner? How the adjudication of penalties can be done? So it is written over here. First, there will be an issue of a written notice by the adjudicating officer. Adjudicating officer shall send a written notice. Okay. किसको भेजेगा? To whom? To the company who has committed an offense, to the officer of the company who is in default, and any other person.
Same as above.
Yes.
क्योंकि डिफॉल्ट कंपनी
करेगा कौन? यही कंपनी है, क्योंकि उसकी इंडिपेंडेंट आपने बताया वो पर्सनैलिटी लीगल पर्सनैलिटी है, आर्टिफिशियल एक तरीके से. तो आप देखोगे कि इसकी लीगल पर्सनैलिटी होने की वजह से अगेन द कंपनी इज हेल्ड टू बी लायबल. एंड since company cannot act like this only, you have to go through certain, you can say factors with persons who will be working on behalf of the company. So the persons who are in default and any other person other than who is in default. Okay. So here the show cause notice will be issued, right? And in that a period will be given for giving the reply. Why you will not be imposed the penalty. So they will give a period. Within that period, they have to give their reply. And that period specified is that it should be not less than 15 days, 15 days. And it shall not be more than 30 days. So within this prescribed period, they have to give reply to the show cause notice.
शो कॉज नोटिस में पूछते क्या है आपसे?
शो कॉज नोटिस में आपको जो भी ऑफेंस लगाया गया है उस ऑफेंस के तहत अगर कोई पनिशमेंट है या आपसे कोई लाइबिलिटी है वो पूछे कि क्यों ना आप पे ये आरोप लगाया जाए. तो एट दैट टाइम इट्स द काइंड ऑफ दैट दे आर बीइंग आस्किंग योर एक्सप्लेनेशन और टू गिव योर रीजनिंग कि मतलब अपने डिफेंस में आप क्या कहना चाहते हैं.
रीजन, कारण बताओ नोटिस.
यस.
रीजन इन इंग्लिश वी कैन से रीजनिंग इज आस्क्ड that why should you not be penalized.
Yes.
So simple, if you understand this provision, they are saying that show cause notice has been issued and there you are giving the period of 15 to 30 days, and that's the exact line also why the penalty should not be imposed on him.
Yes.
Remember these lines. It will help you.
Yes. And the period, remember the period also. Fine. Now the next step after the show cause notice is issued, now every notice issued shall clearly indicate what default has been committed or what sort of non-compliance has been done by such company or the other liable persons as already explained to you in the above sub-provision. And they will also draw your attention what legal provisions will be attracted and what will be the maximum penalty will be imposed on the non-compliance of that provision. So after that, they will seek for the reply to the notice. So reply to the notice shall be found only in electronic mode. Just to safeguard the time period, just to save the time, what they are preferring that it should be done in the electronic mode only. Okay. And after this, okay, then they will ask, yes, the adjudicating officer, after recording the reasons, it may be possible sometimes they are not able to give the reply within the specified period. So after giving a opportunity of being heard, why they were not able to file this reply within the prescribed time period, they can give the excuse if found to be the reasonable cause, and they may extend that period by exceeding 15 days. Then next is that if after receiving the reply, they feel like that there should be a physical presence, okay, of the persons, any officer and you can say the officer in default, then in that case, they will issue a notice as well as they will give a period of 10 working days from the date of receipt of reply and fixing a date for the appearance of the person. And he may be appearing either through the representative officer or either in person on the date that has been fixed by the court. Now an order will be passed by the adjudicating officer, subject to the writing that everything that order has been passed with that the personal appearance has been sought out, and every detail will be there within the order. And passing of order, the period it will be that within 30 days. If the physical appearance is not required, in that case, 30 days is the period for passing an order, or as per the extended period, whatever we have prescribed above, that is 15 days. And in the other case where the physical appearance is there, in that case, within 90 days of the issue of the notice. Within this period, the order is to be passed by the adjudicating officer. Then next is that date and sign on the order. So every order is said to be complete and property signed and date has been given, and also been mentioning about the physical presence of any of the parties. Then moving to the next part is the forward of the copy. Whatever order has been passed by the adjudicating officer, they will send the copies to all the parties to this particular pertaining to the case, to the concerned company, the officer in default. The central government is also party at most of the places, and the copy of order shall be uploaded on the website. Okay, and after that, you'll be seeing that where there is a failure on the part of the person to be present, or whatever the reply to be given, they have not been complied with, or they have not been sent in, then in that case, the person will be imposed the penalty. And even there are certain factors for levying the penalty also I have discussed earlier with you. So here also the same thing, considering the size, the nature of the business, injury, nature, repetition of default. But here there are two additional points, that is where there's an unfair advantage or disproportionate gain, where it can be made a quantifiable. And the other one is where is loss caused to an investor or group of the investors or the creditors. So in that case, these factors may also be taken into consideration while deciding the quantum of the penalties. If there are any fixed sum of penalty, then that fixed sum will be imposed as a penalty. And the penalty, whatever is paid, will be paid through the MCA portal. Right? This is important. Sometimes the MCA, they touch upon this issue, okay, how the payment of the penalty is to be made. So this is made through the MCA portal. And whatever the sum has been released by way of this penalty shall be credited to Consolidated Fund of India. This is again in the MCQs is being tested, that yes, whatever the penalty, they has released the sum through the way of penalty, that will be credited to the SFIO. Yes. This is the adjudication of the penalty manner, how it could be done. But once the adjudicating officer may by an order, they has passed or levied the penalties, that in that case, the penalties may be imposed where there is a non-compliance or the default. So they will say either they will impose the penalty for non-compliance, or they will order, or they will direct to rectify the default. There are two solutions you can say. Either they will penalize, or they will say to rectify whatever the default is committed. Then reasonable opportunity of heard is always given here, because it is also the rule of the natural justice that the parties should be heard. What was the reason for not being either for present in the court, or for not submitting any reply, or whatever may be the reason, they are given the opportunity of being heard. And after that, any person who is aggrieved by an order of the adjudicating authority, they may prepare an appeal. This is a solution. This is always available, the right to the parties. Whenever they are aggrieved by the decision of the lower courts, they will go to the appeal. Similarly, here, wherever the person is aggrieved by the decision of an adjudicating officer, they will prepare an appeal to the regional director. Please note it. Here, the appeal is not to any high court or something, but it is to the regional director having the jurisdiction in the matter. And the appeal shall be filed within 60 days from the date on which the copy of order is made by the adjudicating officer and it has been received by the aggrieved party. That means on the date on which the aggrieved party has received the order, from that day, within that date, you will calculate 60 days from that date, and then you'll be filing the appeal. And after the order has been passed by the RD, you'll be seeing they will either confirm whatever the order has been passed by the adjudicating authority, or they will modify the same, or they will set aside the order appealed against. These are the three, you can say, modes. Yes. Then after that, if the company fails to comply with the order, whatever the order has been passed, and if they fail to comply, then within the 90 days from the receipt of the copy of the order, the company will be punished. Yes. And the punishment has been described, the range, the 25,000 to 5 lakh rupees. Okay. And where there is an officer of a company or who is in default and fails to comply with the order with the same period of 90 days, then in that case, such officer shall be punishable with the imprisonment, which may extend to 6 months. Okay. Up to 6 months. This is the higher side, not more than 6 months, or with fine. Right?
कंपनी को तो हम इम्प्रिजन कर नहीं सकते ना.
Yes. The persons who are doing the act, who are responsible, so they will be punished then with fine not less than 25,000, which may be extending up to 1 lakh, or with both. There can be either imprisonment or the fine or both. Got it? So
Here are some of the queries.
Yes. The first one is asked by Janvi.
So Janvi has asked about the meaning of producer companies. So producer companies is very much a part of
yes, actually it's
the
Companies Act. Yes, it's the part of the Companies Act. But for the students, let me tell you, the producer companies are out of scope of coverage of
yes.
syllabus. They are not relevant and applicable for the student from the examination perspective.
But just for your understanding, we can tell you that producer companies are the companies under the Companies Act with the objective of production, harvesting, procurement, grading, all such kind of things. And they will be dealing in these, and the export of their primary products they will be giving to their members only. So everything is by the members, and their main work is in relation to production, harvesting, and procurement, grading, such things. With this, we will be taking a break as of now for 10 minutes. Right now it's 7:36. And if there are more queries, please do write your queries to us so that we can solve them. And we will be seeing you back at around 7:45. So right now it's 7:36, and see you in 9 minutes, 7:45.
Welcome back, students, after a short break, and hope you had a glass of water and got a little bit energetic to go further with the session. Yes, as far we are seeing the queries, we have received a query from Viraj Desai. He is asking about the meaning of adjudication. Basically, adjudication means the judgment. If you see in the simple word, what adjudication? Adjudication means the judgment that is given by the court, and it refers to the process of settling a legal case or claim through the court of justice or the system, through the court or in the way of the justice system. So this is basically how the judgment is given for settlement of any kind of the claim or the issues through the way of the court. This is adjudication. Fine, Viraj, hope it has been clarified. And then moving to the next query that has been raised by Janvi. Janvi is asking that in case the maximum time limit is 30 days, suppose in case the time provided under point second is 25 days and the days of filing reply is 10 days. So how can there will be a compliance of 30 days? Janvi, to my understanding, what you have asked in the question, you are being confused into two kinds of the dates. First, the date that is prescribed is with respect to the reply to be given for the show cause notice. Okay, so that period they have said from 15 to 30 days. Okay, and when an order is, and whenever they feel like there should be a personal presence of a person, so they fix a date. For that, they send a notice to the person within the 10 days. Okay, within the 10 days, send the notice from the date of receipt of reply of the show cause notice. So this is one thing. And whenever an order is being passed by the adjudicating officer, so he shall pass an order within 30 days of the expiry of the period. Which period? Of the show cause notice. Got it? So in that case, 10 days is respect to for the personal presence of the person, a notice is sent and a date has been fixed for his appearance. This is for that thing. So don't be confused with that part. And second is with respect to the passing of 30 days of an order. And that too, whatever the period has been prescribed in the show cause notice, that period has been expired. So that is the time period within which the order must be passed where the physical appearance was not required. And if the physical presence is required, then in that case will be 90 days from the date of issue of the notice. Okay, these are the different time periods. Make little bit of read this provision because yes, the provision is very, very bulky and it is bit difficult to understand in how much days the notice, reply to the notice to be given, in how much days the date for the hearing will be fixed, and in how much days the order will be passed by the adjudicating authority. So once go through this provision clearly, then you will be easily to make out this time duration and the period, and then accordingly your problem may be resolved.
Now, if the time permits, then looking at the queries that we are getting for this particular provision, then we will try to summarize it.
Yes, let's try to summarize it. Excellent. First, what is the first step? First step is that the central government, first we talk about the appointment. What happens? The central government appoint the officers of the central government through official gazette. This is the appointment part. Okay, and here they will be appointed as an adjudicating officer for adjudicating penalty. This is appointment. This is very simple. I suppose there is no issue in this understanding.
Oh, that means official gazette.
Yes. So now we look in what manner they adjudicate. This is the point of confusion. This is the main provision where students get stuck up and they get confused. So let's try to summarize this concept. The adjudicating officer shall first issue the show cause notice. Okay. To whom? To the company or the officer in default or any other person. So they will issue the show cause notice of these three persons, right? Company, an officer in default, and others.
Don't write these short forms in your exams.
Yeah. And then a reply to the notice will be made online. Okay, whatever the reply is given to show cause notice, why they will not be imposed the penalties, that will be done through online mode only. And where the adjudication officer is of the opinion, they require the physical presence of these persons, then in that case, he will serve a notice within 10 working days of the reply of the notice. Remember, wherever there is a requirement of a physical presence of the company or the officer in default or the other, he will serve a notice within 10 working days of the reply of show cause notice and will fix a date for the hearing or the appearance.
Within 10 days
Yes.
of
reply of show cause notice.
Of reply of SCN.
Yes.
For which we said that 15 to 30 days time period is given from the point of view of that we are asking you that why that this penalty should not be imposed on you. Once that reply is received, then after that 10 days,
yes,
if physical presence is required,
then they will fix a date for the appearance, right? And what will happen? A reasonable opportunity will be given for hearing, right? And after that, they will pass an order. Adjudicating authority, after giving an opportunity of being heard, after the physical presence of the persons, they will pass an order. Then again, the time period is there. Within 30 days of expiry of period, kiska? Of the show cause notice. Where no physical appearance is there. जहाँ पे physical appearance नहीं है, वहाँ पे 30 दिन. किसके? Of the expiry of the period of the notice, show cause notice, right? And second thing, जहाँ पे physical appearance हुआ है, where there is a physical appearance, they are within 90 days of, of you serving the notice. इन्होंने लिखा है serving the notice. And here we are presuming the notice means that notice, show cause notice. फिर इसके बाद आपका आता है imposing penalty. और या तो पेनल्टी इंपोज करेंगे फॉर नॉन कंप्लायंस और दे विल और आइदर दे विल ऑर्डर टू रेक्टिफाई द मिस्टेक्स. This is there. And after that, once the person who has received the order of the adjudicating court, then there, the person who is agreed by an order, he can file an appeal. वो appeal file कर देगा. किसके पास करेगा? Before the regional director. और कितने दिनों में करेगा? Within 60 days from the copy of order made available to the aggrieved. 60 दिन के अंदर अंदर वो आरडी को अपील फाइल कर देगा where he is aggrieved by an order of the adjudicating officer. वहां पे भी reasonable opportunity will be given, the same thing. और वहां पे या तो रीजनल डायरेक्टर उनके ऑर्डर को कंफर्म करेगा और will modify और will set aside the order. जो रीजनल डायरेक्टर है before whom the appeal is made within 60 days from the receiving of order by the aggrieved party, he will be given a reasonable opportunity. उसको सुना जाएगा and then the RD will pass an order. They will either confirm the order, whatever been passed by the adjudicating officer, or will be modified or will be set aside. And if the company now fails to comply with the order that is being passed within 90 days from the order which has been passed by the court or the RD, then in that case, the fine levied is 25,000 to 5 lakh rupees on the companies. And if he's an officer in default, in that case, imprisonment up to 6 months plus imprisonment होने के बाद आपको बता रखा fine up to 25,000 to 1 lakh या फिर both. बहुत ही सिंपल है, इसके अंदर कुछ नहीं है. उनको जो भी ऑर्डर चाहे वो एजुडिकेटिंग ऑफिसर ने पास किया हो और whether it has been passed by the regional director under an appeal, in both the cases they have to comply with the order. And if there is an indiscrepancy in the compliance of the order within 90 days from the receiving of the orders, either of the adjudicating officer or of the RD, then they shall be punished. The company as well as the officer in default and the other person. So this is the summarized way of the adjudication of penalty. Hope you have understood, and we have tried our best to simplify this bulky, you can say, provision, a difficult provision, lengthy provision, so that your queries is being sorted out. So now moving to the next part.
In short, there are 5 kinds. So if you have listened to all the discussion that is going, if you know these time limits,
yes,
and at the end the amount or the quantum of penalty, and you have read the provision thrice or quarter times, and then you can easily write the whole of the provision in examination.
Yes, and even in this time, in present examination, there has been a question asked on this particular adjudication penalty where There has been sought that a physical presence of the person is there, and in that case, the order was not passed within the prescribed time period. Then will that order be considered as invalid? So here, the rule prescribes that it says that no, merely just that the order has been passed after the prescribed period, it will not be considered as invalid. So this was the question asked. So you should read the complete provision, and whatever the proviso is given in line with the main provision, you should understand its relevance and its interpretation. Sometimes the questions are being also asked to check your understanding of the legal provisions. So here, similarly, the question has been tested. What happens if after the period, what has been prescribed or passing of an order, if an order is passed after that period, then what will happen? Will that order be invalid? No, it will not be invalid because law clearly specifies that.
So let's move on to our next very important topic, and one of the favorite topics of like special courts is a very favorite topic. The next favorite topic here is this NCLT and NCLAT.
Yes, this is one of the most important adjudicating mechanism under the Companies Act 2013. Earlier in 1956 time also, it was being given, it was given a year, you can say it was
prevalent at that time.
Yes, it was given, it was notified, but it was not made effective.
Functional, it was not functional.
By that,
you must have heard the word tribunal.
Many times since from 2002 amendment, this word has been introduced, this body has been introduced.
CLB, tribunal, these are.
Yes, but they were not made effective. Okay.
Tribunals were not made.
Yes, but under the 2013, these NCLT and NCLAT has been made fully effective and functional.
So and NCLT is your National Company Law Tribunal, and A is added for the Appellate.
Yes. So the provision is being governed from section 407 to 434 of the Companies Act 2013. You should read with at least with the range. If you are not able to retain each and every section, to at least if you're reading these provisions, sections number with range also, it will give you some sort of idea. Yes, from this to this section, this provision is being contained over there. So, okay, so now when we talk about the Companies Act, I'm telling you, I'm not taking much of your time in making all this to explain you, because already the notes are available with you. And this you can refer anytime at your convenience and read it.
We will be uploading the
notes. Yes. If you see it, when we talk about the NCLT, so NCLT is basically said to be a quasi-judicial body. Yes. This is one of the terminologies that is being used for the NCLT. So what is a quasi-judicial body? So it is basically a non-judicial body, right? Quasi means something partially. Okay.
You must be very conversant with this word quasi in your times of contracts.
Yes. So it resembles, it is not actual, but it resembles something which is resembling to it, but not in actuality. So it is a non-judicial body, and it can be an individual or a body with powers resembling a court of law. Got it? And some of the important statutory bodies that you will be seeing is like CVC, that is Central Vigilance Commission, or you can see CIC, that is the Central Information Commission. So these are the example of these quasi-judicial bodies. And similarly, these NCLTs and NCLAT, they are the quasi-judicial bodies over here, right? And if you see the composition of this NCLT and NCLAT in a very brief, I'm just making you understand. Excellent. If you see that NCLT and NCLAT generally comprises of broadly the members, they will be having the members.
Excuse me for my writing.
They will be having members. And these members will be divided into two categories of member. One is judicial member and other is technical member. Right? And out of this judicial member, one will be chairperson and or president, because we are talking about the composition of NCLT and NCLAT both at the same time, in order to just make you how you can understand the difference of composition. So here what we have said, commonly there will be a members, and commonly you can see in both the NCLT and NCLAT there will be judicial this member as well as technical members. But with respect to the chairperson and president, so from these judicial members, the president will be appointed for the NCLT and chairperson will be appointed for NCLAT.
So if I write it here,
NCLAT. Chairperson is the person
and NCLT.
for NCLAT, and president for the NCLT from the judicial members. They may be selected.
From the judicial members.
Yes.
If you are referring, so make this diagram, it will be very easy for you.
Yes. And now what is the difference between a judicial member and a technical member? Just an idea, just for understanding. Though these are related with the provision which are not being covered in the study material, but I'm just throwing an insight to just have an understanding. Okay. When you talk about this technical members, so technical members, as the name reveals, the person who has a technical, expertise. Yes. So they are.
This is not covered, but I'm writing.
Yeah. These are the person of proven ability, integrity, and having knowledge and expertise in any of the specific field like law, finance, administration, and so on.
If you see, whenever the word expertise comes somewhere, since we are dealing with the Companies Act, so either they will be business related expertise, like we read about expertise there, experts there. Then at that time we were talking about taxation, and I think company law was there, business related. But now, since we are talking about quasi-judicial bodies, that means the bodies which have to interpret the law and take a decision. So now the expertise will not only be restricted to business, it will be more than that. So expertise in law, finance, etc.
Yes. And when we talk about the judicial members, okay, as the name reveals that they should be a person from the legal background. They shall be a legal persons. Okay. For example, the judges of the High Court or the Supreme Court can be the person, either the chairperson or the president. Since they are in the higher hierarchy, higher persons, so they will be from the Supreme Court or High Court judges. They will be from this category. If they are having 5 years of experience of being a judge in the High Court, then he will be elected in NCLT as a president. But if he is having the experience of being a judge in Supreme Court, then in that case, he will be nominated as a chairperson of NCLT from the judicial members. This is just for your knowledge. They can be the judges either from the High Court or from the Supreme Court for being a president or the chairperson.
Higher knowledge, and then you get recruited at the higher position.
Yes. And with respect to the rest of the judicial members, they should be an advocate in the court with the requirement of the specified, you can say, experience under the Act. So they can be the person from the advocate, those who in the practice actually. So they will be the judicial members. So this, in a simplified manner, I have just explained you the composition.
So JM I have decided being bifurcated into two, and then TM, you have seen that they are just technical members.
Yes.
Okay.
And now, moving to the next important aspect of the NCLT.
Let us just open the notes first.
Yeah.
So, if we are moving on to...
Yes.
So the next important point here is you have the notes with you, so you can read the details here. We have already explained this chairperson, judicial members, president, technical member. We have already explained it to you. Moving on to further thing, that is order of the tribunal. Since they have to decide a given incidence, or rather we should say they have to give their decision about a case that has come in front of us, a situation that has come in front of them. So they have to now give a order also. They have to give a decision. So passing of the order. The tribunal may pass such orders as it thinks fit. Why? What I think as an NCLT, what I think is fit, I will give that to the parties to any proceedings before it are given, and those parties shall be given a reasonable opportunity of being heard. Every time an order is being passed, you always need to give a reasonable opportunity of being heard. You cannot take a decision without hearing the aggrieved, or even if you're not the aggrieved, you cannot give a decision without hearing both the parties. You need to hear both the parties, then only you can pass an order as you think fit. Here, as you think fit is your NCLT. Then amendment in the order. What do we mean by an amendment? Suppose an order has been passed and the tribunal thinks that they are not satisfied with the order. There can be n number of reasons. After passing of the order, they may think that we were not having all the proofs and we have given the order, not given the correct order. So they can amend that order. So the correct word here is that the tribunal may amend an order passed by it at any time within 2 years from the date of the order. And what is the objective? With a view to rectify any mistake apparent from the record. And shall make such amendment if the mistake is brought to its notice by the parties. So if any party has brought it in front of the tribunal, then they can rectify. Time period is your 2 years. Send the copy of the order of the parties. Obviously, we will be giving it to all the concerned parties. The tribunal shall send a copy of every order passed under this section to all the parties concerned. Now, this is very, very, very important. Provided no such amendment shall be made in respect of an order against which an appeal has been preferred under this act. What does this line means? Suppose NCLT has passed an order and the aggrieved party is not satisfied with the order, and they have already preferred an appeal to the higher authority. Then at that time, NCLT cannot say, I have come to know the mistake, so I will rectify, even if it's falling within those 2 years. In that case, NCLT is not allowed to make an amendment to its already passed order. Right. So we have an illustration with respect to this, and I will be just explaining this to you in brief. You can read it. An order was made by NCLT and it was challenged by the company within 6 months of passing of the order. Okay, so there is an aggrieved party here. Then in the meantime, the party makes notice and notices a mistake in the order passed by NCLT. Then this party goes to NCLT and tells about the mistake. Now tell me whether NCLT can do on its own.
Whether such an order is valid or also not, or cannot do, that is what, whether they can initiate it on own, or what is the requirement. If you see, already Shraddha has explained you the provision very well. It can be done only when it is brought by the notice of the parties. So first of all, the parties should go for rectification of the mistake. Okay. The first thing is that part. Second thing is that of the time period. Yes, it should be made within 2 years from the date of the order. So if you're seeing it is within that time period. So considering that, what is the thing? But no, what is given over here? The tribunal met any time within 2 years from the date. They can make an order because it is done with the time period.
So this 6 months time period is valid.
That is valid. Even the notice, it has been on the intimation of the notice of the party. That is also valid. But now due to the proviso part, what it says that wherever any appeal is lying to that order of the NCLT, then in that case, no amendment shall be made
by NCLT.
Yes, because of the compliance of that two condition, it was valid. But due to the falling under the proviso part, that amendment cannot be preferred, and therefore the application made for rectification of error in the order cannot be made. So sometimes they test you these kind of things. So you should read properly the question and the given informations in the question. In order to confuse you, they have given every requirement, but along with that, they mentioned one line that an appeal was filed by the party.
So all of the other things were in compliance of the provisions. It was just one thing
that was changed your answer.
Yes.
So need to have understanding of the provision, as well as you should read the question properly to meet up the requirement of the questions also.
So next is your section 421.
Yes. Now in 421, the thing is that whenever an order has been passed by the tribunal, and suppose there is a person who is aggrieved, by an order of tribunal, then what will happen? In that case, the person will prefer an appeal. Okay, where the appeal can be made? Appeal can be made to the appellate tribunal. Okay, got it? And it also says, when appeal can be made, that has been given. Now, when no appeal shall lie, this is also given a condition. It says, when the parties are in consent, that means no appeal shall lie to the appellate tribunal from an order made by the tribunal with the consent of the parties. Where the party agrees, we shall not go into an appeal. There the appeal shall not be lying in that particular situation. Now, the period has also been given and defined for filing of an appeal. So what it says that every appeal shall be filed within a period of 45 days. Remember the time period, 45 days. And from the date of the copy of order that has been received, okay, from that date, you will see within 45 days that you have to calculate. It should be calculated from which date?
From the date the copy of the order of the tribunal is made available to the aggrieved person. Because when the aggrieved person receives the copy of the order, then only the time period of 45 days can begin.
Yes.
Then this appellate tribunal may entertain an appeal. There can be reasons, possibility is there that there can be reasons because of which they cannot do it within those 45
period. Yes,
45 days. So in that case, the period can be extended further by 45 days.
Yes, but proper sufficient cause is to be there. That will be taken and looked by the court, and a proper opportunity will be given to the parties why they have not filed this appeal within the prescribed time period.
Then this extension obviously is at the sole discretion of the tribunal, that you cannot get. If the tribunal thinks it deems fit, then only they will give this extension of 45 days.
Yes.
Then passing of order at 80. On the receipt of an appeal, after giving the parties to the appeal a reasonable opportunity of being heard, pass such orders. Just learn these three words: confirming, modifying, or set aside. Why I'm saying that learn these three words? Whenever an appeal is preferred to a higher authority, obviously they will be doing what? Either they will confirm what the lower court has done, or they will modify it, or they will set it aside. So here also it's the same thing. When they receive the appeal and when they have given the opportunity of being heard to the parties, then they will pass an order as they deem fit, confirming, modifying, or set aside.
Because in appeal, what happens, they won't again go into the complete, trial of the cases and everything. They only just look after what is the question of law over there. And on the question of law only, they consider again the orders, and accordingly, whatever deems to be fit, they give the decision, either confirming the same if the decision is right, and or they will consider that due to certain lapse of the law, due to question of law in the particular situation that is missing, or something is been left out or not considered, or has been incorrectly decision has been taken on those points, and it will be modified or it will be set aside.
Then copy of the order of this appellate tribunal. Who will they give? Who are the parties here? The parties to appeal and the tribunal, because here the tribunal, the lower court, I can say, or the lower quasi-judicial body is also a party here. So
yes,
the copy of the order shall be given to the tribunal and the parties to appeal. Then here we have expeditious disposal by tribunal and appellate tribunal. The main reason for NCLT and NCLAT, like special courts, is also that this is a specific body for the Companies Act. Okay, main things should be decided for the Companies Act for speedy trial. So that's why they want. If you see the timelines here, look like 2 years, 3 years. The timelines are very short within which they have to pass the orders. So here we have again expeditious disposal. So it's a speedy disposal. Every application, petition presented before the tribunal, plus every appeal filed before the appellate tribunal, shall be dealt with and disposed of it as expeditiously as possible. Means jaldi se jaldi, as ASAP, as early as possible. So we will not write the word ASAP, we will be writing the legal word, which is expeditiously. Every endeavor shall be made by the tribunal or the appellate tribunal for the disposal of such application or petition within a period of 3 months from the date of presentation. Obviously, these dates, like if we are saying 3 months, so it will be calculated when you have received the appeal. Next, where an application, petition, appeal is not disposed of within the specified period, that is within 3 months, reasons are to be recorded for not disposing of the appeal within the prescribed period. The president, the chairperson, may, after taking into account the reasons so recorded, extend the period not exceeding 90 days as may be necessary. So why this is so? They want that whatever the case has come to the tribunal or the appellate tribunal should be decided as early or as possible. Reason being, it should not be the case of tariq pe tariq, tariq pe tariq. So somewhere they have made the members of the NCLT and NCLAT responsible for passing the order. And when that is done, they will obviously try to expedite the matter and bring out the result. So the time period is provided is of 3 months. And if it's not done within 3 months, then the reasons are to be recorded in writing, that what was the reason for delay. And then if the president and chairperson feels and taking in account the reasons, then they can extend this period by 90 days.
Yes. Let me explain in short these provisions. Let's go to this diagram here. If you see that regarding the order passed by the NCLT, this is given under section 420. The NCLT passes an order. Now, the disposable, when the time period of disposal of these cases under the NCLT is prescribed under section 422. So it says that within 3 months from the date of presentation of petition, plus if there is a condonation of delay, then by 90 days, the additional period may be provided for the order to be passed by the NCLT. This is in very short, the 420 explained where the order is passed by the NCLT. It is simply says within 3 months from the receipt of the petition, filed when the petition has been filed, within that 3 months plus 90 days of additional time period in case of condonation of delay, whereas there is a reasonable cause for not filing the petition within 3 months. Right? Now, next part, whenever any aggrieved party is there, he will file an appeal to the NCLAT. Now, what it says, it is being dealt under section 421. Okay.
Just a moment, I will be moving further.
Yeah.
Yes.
NCLT, appeal against the order of NCLT under section
Aggrieved hoga yahan se.
Yes. Now he will move to NCLT. Now what will happen? In that case, the order needs to be passed by NCLT within 45 days from the order received by the aggrieved party. Within 45 days of the order which has been received by the aggrieved party, so within that date, the order needs to be passed by the with respect to the appeal by the NCLAT, and if that period the order has not been passed, then it will be further extended by 45 days.
So here we have
45 plus 45.
आसान है याद करना. देखो 3 की टेबल आती है ना, you know the table of 3 months multiplied for 90 days aggrieved, then we have half of 90 is 45. If you see, it's the total this only.
And again here also the matter will be disposed within 3 months from the petition presented before the NCLT of the appeal. So within the 3 months it will be done, and in case for condonation of delay, again the 90 days will be granted additional time. Okay. Now this is about the NCLT. Now Supreme Court, wherever the person is also not satisfied with the order passed by the NCLAT, then again he will move to the appeal before the Supreme Court under section 423 of the Companies Act. Fine. Here the person who is aggrieved from the order of the NCLAT from the Appellate Tribunal, he can file an appeal within 60 days from the receipt of order of the NCLAT. Very simple hai. ठीक है, 60 days, and further period is more granted in case he fails to file within that period. That is the grace period, again the condonation of delay by 60 days. That can be done. But whatever the normal time period is awarded, that much only additional period is being awarded for filing of, this application in case of condonation of delay. Okay, in Supreme Court, appeal can be only filed on the question of law. Remember that.
Yes. And if you see here, they have not written High Court.
Yes, High Court is not there. Simple NCLT, NCLAT, and then Supreme Court.
Yes.
The next, let's go to notes. What's the next? Yes.
So we have, since we are already at 8:27, let's quickly take this illustration.
Yes. Here what happens, here is a company, public company, Eric Limited. Here his company has not conducted his business from a sound business principles that need to be complied with for commercial practices. So here the shareholders of the company filed a case before the tribunal on 1st of September 2022 with a request to inquire into the, this action of the director, whatever they has done, they have not complied with the sound business principles. So tribunal, after making a proper inquiry, they passed an order against the director on 31st March 2023. These are the facts when the petition has been filed before the tribunal on 1st September and the order was passed on 31st March 2023. Now, this is question being testing the legal validity of order, right? So you should understand that they are asking that whether within the period in which the order was passed, is it in line with the requirement of the section? So you need to check with the relevant provision, that is section 422. Okay. In this, because we have created how much period of disposal of any case under the NCLT or NCLAT will be done. So it clearly prescribes that within 3 months from the date of order received by the aggrieved party, right? And if within this 3 months time period, if it has not been done, then condonation of this will be there by further 90 days. So if you see, by 3 months from 1st September, it will falling on 30th November 2022. And from there, 30th November, we will calculate the next 90 days. So it will be coming on 20th February 2023. And since the order has been passed on 31st March 2023, so that is being time barred and it is beyond the time period specified over there. So hence the order passed by tribunal is not valid.
We have already covered this appeal to Supreme Court.
Yes.
And so
now this procedure
for tribunal and appellate tribunal.
ये भी बहुत important है. जैसा अभी तक हमने special court में देखा, we were saying they were having the same power as that of criminal courts under the CRPC. And here we are finding they are of the nature, these tribunals and appellate are of the nature of the civil courts because they are looking into the matter from the considered as the civil suits. Okay. So here, whatever the procedure has been laid down in the CPC, the same procedure will be followed by the tribunal for regulating their own procedure for disposal of the proceedings. So along with the civil code, they are not only restricted up to the CPC, but they are also being guided by the principles of natural justice. Okay. And along with that, they will also be regulated by the Insolvency and Bankruptcy Code 2016, since now the provision of insolvency has also been incorporated under the Companies Act for harmonizing the provisions or the trials or the process under both the Companies Act and the codes and under, yes. So now you can see they will be regulated by the natural justice plus IBC code and the rules made thereunder. So we can say these tribunals, they have the power to regulate their own procedure as per requirement. If they something which is related to the corporate persons, then definitely they will go into the Insolvency and Bankruptcy Code with respect to the rights or duties of the corporate persons. Yeah. And if it is related to the, companies, then it will go under the Companies Act. And when we talk about the natural, this principle of natural justice is very simple. It is almost applicable everywhere. This is one of the important, principles which is taken that nobody has been affected or his interest has been affected. So what are these three? There are three basic essential principles. First one is that justice should not only be done but be seen. दिखना भी चाहिए. ऐसा नहीं कि आपने कहा और हो गया. वो दिखना should be reflected in your whatever decision or orders or in the decree has been passed. Then one cannot be judged in his own case. Okay? खुद अपने आप डिसाइड नहीं करोगे आप, ठीक है? So there we go to the third party. Whenever there is any dispute, we go generally to the third parties for the redressal of disputes. Then nobody should be left unheard. So we have everywhere we have seen, whether in the special courts or under the NCLT, that a proper opportunity has been given to the parties to be heard for whatever they have not done in compliance with the requirements under the Act. So we have complied with all these three, essentials of the natural justice principles. So this is also the required whenever tribunal or appellate tribunal go or do any proceedings, they just follow these CPC plus principle of natural justice plus the insolvency and bankruptcy code. So they can accordingly, wherever required, they can regulate their own procedure. Now, since we have said that they will go by CPC also, so that means they have the same power as are vested to that of the civil code, right? So if you see with respect to summoning part, whenever we require attendance of any person or for examination of a person, we go as per the CPC code. And there we send a summons to the person for their personal attendance. So for summoning, civil code has laid down the proper procedure. They will go accordingly with that. Whenever we require any production of any document, then again the civil code will prevail over there. Or when we talk about any requirement of public records, document or examination of the witness, or where there's any setting aside of any ex parte decision or any other matter, then we go with the power that has been vested in the civil courts. Now the nature of the order of the tribunal and appellate tribunal and its execution. Since we are saying it has the power of the tribunal courts and as per the CPC, as per the civil courts, so now they are saying it will be the order that will be passed same as the decree made by a court of the civil courts in a suit pending therein. Because in the civil court, whenever any order is passed, it is said the decree. So it is the same, okay? And it is being said that the execution of order to the court will be done within the local limit of whose jurisdiction. In the case of a company, where the register of the office of the company is situated, there the decree or the execution of order will be done. And if in the case of any person or the officer in default, then it will be at the place to the person where he resides or carries on business or works for gain. So in either of the three places where the person lives, so in that place proper, there will be an execution order of the tribunal or the appellate tribunal. Now, what will be the nature of the proceedings? It is being said that the proceedings before the tribunal and the appellate tribunal shall be deemed to be for particular these two specified reasons, the nature of the courts varies actually. In generally, we said they will be having the CPC and civil suits powers, okay? But particularly with respect for the purpose of section 196 of the IPC code, Indian Penal Code, there the proceedings will be deemed to be a judicial proceeding. And what is this 196 of the IPC code? So we have given here for your footnote for your reference that any things which has been falsely fabricated or given falsely, just considering or trying to attempt to consider as a true or genuine evidence, but it is being a false or the fabricate evidences. So in that case, it will be treated as a judicial proceedings. And where it is respect to 195 of the CPC section as well as for chapter 26 of the code of the this CPC, you can see in the footnote we have also given for your reference that where there's a contempt by the public servant, in that case, the tribunal and appellate tribunal will be deemed to be a civil court. And for chapter 26 of the CRPC deals with the offences affecting the administration of the justice, where there's a contempt of court, definitely your administration of justice is also being somewhere affected. So in that case also, the appellate tribunal and tribunal will be deemed to be a civil court for these purposes. Okay. So hope it is clear to you with respect to this, how the proceedings takes place in the appellate tribunal and the tribunal. Now with respect to power to punish for the contempt. So this is basically what is the contempt, whenever there is a disobedience or disrespect of the court, or there is an interference in the legal proceedings or the legal work of the court, it is said to be a contempt of court. And this is being regulated by the Contempt of Court Act 1971. 1971, okay? 1971, okay? Now, if you see with respect to this part, they have said whatever the High Court has been given power for the contempt of court under this contempt of this Court Act 1971. The same power will be given to the NCLT as well as the Appellate Tribunal, but there will be a reference into into a High Court as a Tribunal and Appellate Tribunal. Whereas with reference to the Advocate General, it will be set to the law officers and the central government may specify in this behalf. This is only the difference. Rest, it will remain the same. Whatever the power has been given, that will remain the same to the NCLT and Appellate Tribunal. Now, delegation of powers. When we talk about the delegation of powers, it says that the Tribunal or Appellate Tribunal, by specific a general order, they may delegate their powers either to any of its officers or employees or any person so authorized by it to inquire into any matter, whatever the matter is pending or any proceeding is there. So they may inquire it, or they may file an appeal, or they may report to it in the specified order. So every kind of the power has been delegated to the specified persons. Now, prosecution of action taken in good faith. So it says that the tribunal, the president, and all the members and the employees against the appellate tribunal, there are chairperson and members and employees, or the liquidator, or any person who has been authorized under the tribunal or the appellate tribunal for the functions. So in respect of any loss or damage caused or likely to be caused by them in good faith. If something is done in the good faith, then in that case, you can say there will be protection of action to be taken against the person that has been specified over here. Means no suit, no prosecution, no legal proceedings will be taken because the act was done in good faith. Okay, so they will be safeguarded and given the protection. Now, power to seek is the assistance of Chief Metropolitan Magistrate.
So if we see that now if the tribunal feels in any proceedings of the winding up, so then in that case, what they can say that they can request in writing the Chief Metropolitan, Chief Metropolitan Magistrate, the Chief Judicial Magistrate, or the District Collector, within whose jurisdiction such books of accounts or such property is there or other documents are there, then they can ask them to take the possession of these. Okay. In case there is a need, then they can take the help from these people also, CMM, CJM, and DC, and then these authorities can take the books of accounts or properties under their control. But this can be done on a written request by the tribunal. And this is being done in the case of a winding up order or in any proceedings under the IBC. Then the next is, now they have taken the possession, then what can they do? The CMM, CJM, and DC, when the request has been made to them, they can take the possessions of these three things, property, books of accounts, or other documents, and cause the same to be entrusted to the tribunal or other persons authorized by it. They have collected, now they will give it to the tribunal. May act as may be necessary for securing the compliance. So for securing the compliance of these documents or properties, they can take the necessary actions for complying with the directions of the tribunal. No act to be called in question, no act of these judicial people, CMM, CJM, and DC, done in this section shall be called in question in any court or before an authority on any ground whatsoever. Suppose a tribunal has asked them to do it, and the CMM and CJM or DC has done it, then at later point of time, they cannot be questioned that why did you do it? Because they did it on the written direction of the tribunal. Then the next is civil court not to have jurisdiction. No civil court shall have jurisdiction to entertain any suit, proceedings in respect of any matter which the tribunal or appellate tribunal is empowered to determine by or under this act or any other law for the time being in force. Also, no injunctions shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act or any other law for the time being in force. So what they are in fact saying, that if there is a matter which can be decided by tribunal or the appellate tribunal, which the tribunal or appellate tribunal is empowered to take decision on, then that cannot lie with the civil court having the jurisdiction, because obviously there will be a jurisdiction, and in that case the civil court shall not have the jurisdiction to entertain such cases. Vacancy in tribunal or appellate tribunal not to invalidate acts or proceedings. Suppose a decision has been given and there was some what should I say? There was some existence of a vacancy in the composition of the tribunal or appellate tribunal.
Some member was not there.
Yes.
It may be possible.
But just because of that vacancy, the order that has been passed, that will not be invalidated. No act of proceedings of the tribunal or the appellate tribunal shall be questioned or shall be invalid merely on the ground of the existence of any vacancy or defect in the constitution of the appellate tribunal. If a person is not available and a decision has been taken, it's taken. You cannot say that decision will not be held valid because such so and so person was not there. Then the next is right to legal representation. A party to any proceeding appeal before the tribunal or the appellate tribunal may either appear. We need to decide that who will appear before the tribunal or the appellate tribunal. Either the person can appear himself, that is in person, or they can authorize one or more such persons, such as a chartered accountant or a company secretary or a cost accountant, legal practitioner, or any other person to represent him, and that person can represent the party in front of the tribunal or the appellate tribunal. Okay. Then the next is limitation. The provisions of the Limitation Act 1963 shall apply to the proceedings or appeals before the tribunal or the appellate tribunal.
Yes, if something is time barred, then you cannot go and
overrule that.
Yes.
Yes.
So there the Limitation Acts
is applicable.
Yes. Now here are certain self-assessment questions because we are
done with the topics,
and we have tried maximum to cover the relevant aspect of the redressal mechanism. And now let's test out how much you have understood the concepts. So if any, let's see how many students of you are going to give the reply. So let's go with the first question. The trial of an offense under Companies by special court shall be of such an offense. Yes, my dear student, please tell me which is the correct option. Option A, which is punishable with the imprisonment for a term exceeding 1 year, or which is punishable with the imprisonment term not exceeding 2 years, or which is punishable with imprisonment for a term of 2 years or more, or which is punishable with the imprisonment for a term not exceeding
2 years.
Yes. So
let's see who all have responded.
Yeah.
Okay.
Let's find out how many of you have understood the concept. Actually, the concept is very much given in that what all offense can be tried by the special courts.
Great.
Very good. Yes, the students are marking up that option. C is the correct option. Yes, because the section 435 clearly specified the special courts can try the offences which are punishable with the imprisonment of 2 years or more. 435 of the Companies Act. So here the correct answer is option C. And very good students, and we are very glad to see and very happy to see that you are able to understand the provisions. Now moving to the next important question is that the tribunal and the appellate tribunal shall not, while disposing of any proceedings before it, or as the case may be an appeal before it, be bound by the procedure laid down in. Already told, for special courts, CRPC powers, and for tribunal, though I'm just giving you the answer, but yes, looking forward for your reply. What could be the correct answer?
Every student has written the correct answer.
Yes, option B, the Code of Civil Procedure. Now moving to the next question. Yes, for the purpose of providing speedy trial of offences under the Companies Act, who have the powers to establish or designate as many special courts. Dear, all you must be seeing everywhere.
The
One
powers are
supreme authority was there for establishment of the following adversarial mechanism, whatever we have discussed in the chapter, and that was yes, absolutely right. That is the option C. That is the central
so students,
government.
you have understood up till now. I think all the students are answering correctly.
Yes, that
Great.
Now moving to the next question. As per the Companies Act 2013, every petition filed before the tribunal shall be disposed of. Yes, this is section 422. It clearly defines that within 3 months from the date of presentation. This is the correct answer. And what will the condonation period? Plus 90 days. Remember, why we are reiterating every time? Because this will make you to remember the time period within which the application is to be presented, or after the condonation of the period, what shall be the time period. Now, moving to the next question. Do anything contained in the CRPC, any offense which is punishable under the Companies Act 2013 with imprisonment only, or with imprisonment and also with fine, maybe which kind of the offense, because you have properly read it about the, but yes, then also you must be knowing it with the names. Compoundable means something which is there which the party can settle with respect to any of the offense, whether it with respect to the imprisonment part or with respect to, you can say there is settlement with respect to the, that penalty, because basically it can be done with the fine only. I'm giving you again the hint also besides with telling you this thing. So looking forward for your correct option, when any offense is punishable with imprisonment only, or with imprisonment and also with fine. So what could be the nature of the offense? Yes, Shraddha, what students will be marking? You just let me know. Till the time student give the answer.
Ma'am, all the students are, I think just explain to them once what is
Compoundable.
Because none of the students till now have given the correct answer.
Very simple. Compoundable. Compoundable means such forms of the offenses which can be compromised by the mutual agreement of the parties. Okay. They can compromise to the certain extent, whatever the penalties through the way of the fine has been levied, somewhere through the way of the penalties, they can minimize certain amount, or they can, by just making the settlement or the compromise, they can go with the going of the solutions, or you can go with whatever the decision is taken by the court, just considering that yes, party are agreeing on that point. So they can go for the settlement. So here, since the imprisonment only, or with imprisonment and also fine, as already said, is only possible with respect to fine only.
So
compoundable offense.
Armiha has marked the correct option. So
yes, the offense shall not be compoundable because your fine is also there. If fine would not be there, only imprisonment were there, then in that case, that offense cannot be compounded. But since here it is said the imprisonment with fine also, since the fine has, again, I'm just correcting myself. Since imprisonment is also there, so it is not compoundable because it is only possible with the fine.
Only
compounding of offenses is only possible with the fine case only, but where there is an imprisonment also, so there no settlement can be done, and in that case, it shall be considered as non-compoundable. So yes.
Armiha, thank you for understanding the concept. And here option C has been marked as shall not be, because that cannot be. If the may is there, then there is a discretion.
Yes, absolutely. So
this brings us to the end of our session.
Yes. So we are just finding out that yes, you students are very well mark the correct option. These are all the minor differences in the options given. So if you don't have the clarity, definitely you would have been confused while marking the correct option. And this is what the intent of, our paper is also, that you should have a conceptual understanding of the concept, because MCQs,
they even direct questions, like we say that, which are very direct, which are provision based. In that also, though we are saying they are direct, but then also they will be testing the concept somewhere.
Yes, and
at final level it is necessary also.
Even if you see the descriptive types of the question also, they are asked of both the natures. It can be application based also. Application is simply the application of the law. Some certain situation will be there, as he has given in the illustrations over here, to make you understand. They can be asked in the descriptive nature of the questions. So that will be also there. So you need to have the understanding of the law, the procedure, how it goes with the process. So once you are clear with the procedure and the procedure, then you will be able to come up with the correct answer. And also direct nature of questions is there. Directly they are testing your understanding of the legal provision. That is also possible. So kindly read these notes. These notes are the simplified, legal provisions for sake of understanding. And at many places we have given a tabular form also.
Format. The charts are there, and if at a later point of time you feel that you can refer the side notes that we were preparing, and you can make them in your notes also. So it will help in easy revision also.
Absolutely. And also that even not only this, you will seeing that our actual chapters is being covered under 26 to 30 pages, but we have here covered up within 19 pages. So some way we have tried to make it crisp,
Wherein we have given examples also, and we have made the charts also. So if you want, you can make it even shorter.
Yes. And also refer whenever you get the time, these lectures, recorded lectures also, because at many places we have explained you through our notes in between during the sessions. That note will also make you to revise the concept in a more easily mannered. And that will be helpful to you in the examination also.
And we have tried to make this very procedural chapter easy for you.
Easy and interesting.
And interesting in the sense that you remember things.
Yes. So these are all the, little bit procedural and boring little bit. But yes, this is also the important chapter, and around 5 to 6 numbers, 4 to 6 number questions are being tested on this topic.
So you cannot skip it.
And further also in your future, NCLT and special courses are very important. If you go into a practice in the corporate sector, you should know what are the redressal mechanisms that are available under the Companies Act. So from that point of view, also this chapter is very helpful. And one query is there of Viraj Desai. So Viraj, we have noted your issue and concern, and we will just let know to the technical persons, and they will look into this issue.
Yes.
Yeah. And with this, we would like to conclude our session. And
thank you, dear students.
Thank you for your patience listening and just being with us.
For such a long time.
Yes, being connected to this session. Yes.
Providing the response to each and every MCQ and questions.
Yes.
Thank you for being such a enthusiastic, or I should say very good audience, obedient students. So thank you.
Thank you and all the best.
All the best.